All right, I'd like to call this meeting to order, August the 5th, 2013, of the Tennessee Auctioneer Commission. Donna, would you like to do the roll call?
I will. Marvin Alexander.
Here.
Bobby Colson.
Here.
Gary Cunningham.
Present.
Jeff Morris.
Here.
And Howard Phillips. Mr. Chairman.
Looks like we got everybody here. Would you like to read the notice of meeting?
I would.
Can you quote it without reading it yet?
Not yet, even though I do it twice a month. This meeting's date, time, and location have been given notice on the Tennessee Auctioneer Commission's website, included as part of this year's meeting calendar since August the 8th of 2012. The calendar was updated on February the 1st of 2013 to reflect the new meeting room number. Additionally, the agenda for this month's meeting has been posted on the Tennessee Auctioneer Commission website.
Run those in newspapers.
Yes, they are, well, we provide the newspapers with them. Whether they run them or not is, no, they're not.
It says that you have to run it in newspapers and
Administration handles that usually.
I was just curious if that's why you did it. No big. Nobody's been after you yet.
All right. The agenda. Would like to review the agenda. Are there any additions or anything?
Chairman, I would like to add an issue to the agenda to review some questions and information brought to us by Mr. Thomas Chafin, who is in the office. I guess wherever you prefer on the agenda. Is here, yes.
First or wait or
It's up to
whatever.
you. I talked to him earlier. He's really doesn't matter to him when you get to it.
Chairman, I move that we adopt the agenda as written and with the addition that Don, the Executive Director, Ms. Hancock.
Also like to add election of officers to that.
I'll second that.
All in favor? I would like to review the minutes and then have the election of officers. And then okay. Just a moment. Yeah. Looking over the minutes, I hadn't looked at them, so.
Mr. Chairman, I've reviewed the minutes and I move that we adopt them as written.
Second.
We have a motion to adopt the minutes by Commissioner Morris and a second by Commissioner Phillips. Is there any discussion on the minutes, any changes or corrections or anything? All in favor? Aye. All opposed? All right. I'd like to do the election of officers for the 2013-2014 year, I guess. Do we have any
I didn't know that, I guess, at this time. I haven't, I don't think I have, maybe. Well, at this time, we'll open the floor for officer nominations. For chairman and vice chairman, first beginning with chairman.
I would like to place a nomination, Jeff Morris, for chairman.
All in favor?
Aye.
All opposed. I I'm sorry. I've never run these, and I didn't know. Well, then, Commissioner Morris is now Chairman Morris. So should we move on to the Vice Chairman? Any nominations for Vice Chairman at this time?
Nominate Howard Phillips for Vice Chairman.
Are there any other nominations?
And we elect Mr. Phillips by acclamation.
All in favor? All opposed? Okay, Commissioner Phillips is now Vice Chairman of the Auctioneer Commission. When does that take?
Meeting or the
I think
next
so,
meeting?
yeah, I think it takes
So you
effect
go-
right now.
So you're going to turn the gavel over to Mr. Morris?
There you go. I wasn't expecting
I'm sorry, I'll be better prepared to do that better next time.
If I had a gavel, I would.
You need to steal one from Bear.
We will order one. How's that? I thought y'all had one.
We've gone through that first section. Now we'll ask for an update on seminars and newsletters from Ressa Orr. Ressa, you want to come up? Ms. Hanson, excuse me. I've known you as Ressa Orr too long.
Ressa Orr Hansen with Nashville Auction School, and we have our October seminar is scheduled in Chattanooga. It's on the north side of Chattanooga at a facility called the Car Barn, which is an interesting fun venue. So that's going to be a neat place to be, and we will be having auctioneer Justin Oakes. He's going to be speaking. I don't have his course title and outline yet, but it will be on seller relations, professionalism, and buyer relations. So it's going to be the October 14th. I'm sorry. That's on a Monday, October 14th.
How far is that from Chickamauga?
Closer to Chickamauga than it's on the north side of Chattanooga. No, it's out kind of off of Brainerd Road in that general area, 41 Brainerd Road. Also, the Department of Revenue will be speaking on sales tax. So those will be the topics that we'll be carrying out for the year, but our East Tennessee venue is set. We will be having a newsletter coming out in September. Mr. Chairman, we always request that we...
Better than the last one.
I hope you do better than the last year.
Figured I'd say it before you did.
Thank you, Bobby.
All right, well,
Always request a letter from the
let's
chairman.
talk about that and see what our message is going to be.
Let's do, yeah, that's good. So we usually try to get those at least 30 days before we go to press. So it's imminent. Okay?
Imminent?
We're working on
Okay,
that
well,
over the next couple of weeks.
Well, I'll be back in the office this afternoon. Call me in the morning.
Okay, great, thank you. And that is my report. Do y'all have any questions?
They was doing the seminar, not the Department of Revenue, but the other.
Justin Oakes.
Oh, Justin.
He's last year's
Yeah, I know.
NAA IAC champion, and he is from Middleton. Great guy.
Next, Judy, you want to go ahead and start with the legal report?
That's fine, or I don't know if y'all wanted to discuss
Well,
it.
you want to go ahead, if you got plenty of time, we'll go ahead and have Tom come up and...
That's fine, I'm here.
All right. Okay. With the additional item that Donna had asked to bring up, Tom, you want to come forward and tell us what we're doing?
All of you have in front of you the paperwork that we received Thursday or Friday? Yeah. Latter part of last week. And I will let you, or Mr. Chafin, present his.
I'm just here today because I checked yes on the box on the application for being convicted of a felony. And I would, it was something that happened many, many years ago when I was young, and I'd really like for y'all to take it in consideration and hopefully let me get my auction license.
Background on your situation and kind of condense this for us.
Large.
Yep. Mm-hmm.
Back in 1990, I worked at Square D in Smyrna, Tennessee. I worked second shift. My father-in-law would come by a lot, got to coming by more and more, but bringing me dinner. And it was, in my work area, he would come in and bring me dinner, and not knowing it, he would leave taking things that belonged to Square D, but it came out of my area. Like I said, that was my father-in-law at the time, and I was young and didn't know any better, and he convinced me, let me back up just a little bit. Square D realized things was missing out of my area, began to question me about it, and of course I didn't have any idea at the time, and come to find out he was taking things out, and being my father-in-law and being young, I took the blame for it, and that's where it all led from. Since that incident, there was, I was in the 1990s, and 90, and I've never been in any kind of trouble since then. I've had 2 speeding tickets in my whole life. Other than that, auction business is something I've always wanted to do, and I had the opportunity to, and realized that there was a box there I had to check yes or no, and I'm honest, and I checked yes, and here I am.
Do it a second time.
Sorry?
Why did you do it a second time?
Being young.
Now, you didn't learn the first time?
Well, it was real. No, I guess I didn't learn the first time. No. It was, I was 24 or 5 years old at the time, and that was my father-in-law, and I didn't, we had a real tight relationship, I thought, and I didn't want to see him, get in trouble, me being married to his daughter and all, and it was just something that I'd done that I shouldn't have.
What was he doing with them? Was it merchandising?
I'm not real sure. It was, I think, tools and some type of material. I don't know, may have. I assume he was, yeah. No. I didn't know anything about it till after I started getting questioning from Square D about it, and and he was the only one that was coming in and out of my area as far as going in and out of the building.
Just by Square D the second time?
Last 5 years as far as jobs.
I've been working for Chatty John's Auction. I work just ringing for him and setting up sales, and I've been doing it a lot longer than that with him, but I work for Fair and Daniel, some helping him set up sales when he needs help and ringing for him, and another company out of Alabama I go just drive to take, I buy and sell at auctions, and I take merchandise there and sell and work in the ring there for Mid-State Auctioneers. Pretty much that's how I make a living, just, and that's why I want to get in the auction business, because I love it. I've always been around it. It's always been a passion of mine, and just something I want to do.
Valid Tennessee driver's license?
Yes, sir.
I just wanted to point out, Ms. Hanson called last week regarding this, and in the apprentice class right now and has not taken the exam yet. So I was to look for that information with this application.
Any other questions for Mr. Chafin? I will entertain a motion as to his application request.
I'll make a motion that we grant him the privilege test, and I do that based on decisions that we've made here before in similar or
Question by anybody regarding the motion? Favor say aye. All against? Congratulations, Mr. Chafin, you've got your exemption.
Thank you.
Now, Julie, if you would, go into the legal report.
Okay. And I wanted to give Mr. Chick a moment to address the commission. He came in here to discuss a particular topic, and rather than have him have to sit through my report, if it's okay with you all, since it's a legal matter, I was going to let him go ahead and proceed, if that's all right with you.
Good morning.
Morning.
There was well, there actually was not a complaint filed, but there was an incident with Vince Trotter that happened early on in his business that was a little bit unique in that it was before they formed an LLC. Very similar to the allegations that we had heard in the other 35 complaints. They had consigned items, had an agreement that they wouldn't sell below the amount. That complaint was not filed with us.
Get you to speak directly into the mic.
Sorry. Again, that complaint was not filed with this commission, but when Trotter filed for bankruptcy later on, they filed an objection in bankruptcy court to make the amount that they believed Trotter owed them, which was $80,000, not dischargeable based on the grounds that there was fraud. And that hearing took place on March 22nd of this year. I went up and watched it, and the judge finally entered an order on that in June, finding that Trotter was personally liable, that he had intentionally misrepresented the people and engaged in that improper conduct. So that's a finding that we've got that's on our books now, so that should he ever attempt to reapply, that's a very valid grounds that we can use. As far as where we are right now, the cases in Chancery Court are still pending. When the judge dismissed our cases and claimed that her order was a final order, we disagreed, and the commission set those aside. But as a precautionary measure, we also filed an appeal in Chancery Court, and the other side filed an appeal in Chancery Court, and those two things are still sitting. He doesn't have an attorney anymore. As a strategic matter, after discussing this with the Attorney General, I think the consensus is that it might be better just to let things sit right now, and because in the meantime he has no license, they're long expired, can't be renewed. So, are there any questions about that? He had a few criminal things that were pending in some other states, and I believe those got dismissed. So I don't believe he's subject to any criminal liability.
You know how long we have to keep those complaints on our list?
Could decide right now that you want to close all the complaints. But what that would cause us to have to do would be to dismiss what we have up in Chancery Court. The problem with that is that would leave what he's got hanging out there, and he could come in at the last minute and decide to follow through on it. So that's why I would suggest that we just leave things as they are right now.
Well, if they could follow legal's advice on that.
And hopefully the two things in Chancery will be dismissed together by the court at some point.
We'll still make our numbers look bad, but I don't care. As long as we keep
They do, but I think the administration understands what the situation is, and
As long as we have that footnote, that's it.
we've got that federal ruling that's very helpful to us.
And if I may.
I'll also note that the bankruptcy judge had no problem reaching her determination without an expert witness, by the way. Anyway, I think in the long run, mission accomplished, and so. That's up to Mark. I think as far as how you reflect them administratively, that's between you and Mark.
Legal has to change that, I think,
Yeah.
or it shows the correct status.
The only question I have is usually when legal monitoring,
Monitoring consent order.
it's possible.
Hey, Julie, now you can,
Put it off as long as I could. No, I'm just kidding. All right. Sorry it's a little longer this month, but not having met a couple of months in a row, just had several matters to present. So I'll try to read as quickly as I can.
here's our legal report.
I gave it as a handout to each of you. Did you get a copy? I have additional ones if you don't.
There it is.
Got it. Does everybody have a copy? I thought I put 5 up there. All right. We'll start with the first matter, which is 2013-005-121. The complainant alleges that respondent was complainant's apprentice for approximately 4 weeks. During that time, complainant alleges that respondent sold guns at auction. Complainant also alleges a number of other matters regarding respondent, including bidding on items to increase the bid after winning, giving the item back instead of using a reserve, not using sales contracts, having checks made out to respondent's wife in order to avoid paying sales tax, selling raffle tickets, which complainant compares to running a lottery, and not having a closing statement at the end of auctions. Complainant states that after complainant removed respondent from his firm, respondent was calling bids on one occasion with no other auctioneer on site. Respondent states that complainant filed the complaint against respondent in retaliation because respondent had recently reported several auction companies that were using non-licensed auctioneers. Respondent states the complainant was the auctioneer for respondent's gallery during the 5 months prior to this complaint with no trouble, and a few weeks before the complainant approached respondent about changing to have complainant as respondent's sponsor. Once respondent made the change, respondent states that complainant seemed to try to take full control of respondent's business, stating that complainant's wife was to be the clerk for the business, which respondent refused. Respondent admits that there were a few guns from various estates sold through the auction, but complainant was auctioneer during those gun sales and never voiced a complaint. Respondent states that respondent has placed bids on items during an auction that respondent was calling, as has complainant according to respondent, but respondent states that it is always announced that respondent plans to bid, and if respondent wins, respondent does not give the item back. Respondent denies the allegation that respondent does not use a sales contract. Respondent states that respondent has an open and active escrow account and denies having checks addressed to anyone else, stating that complainant had no involvement in the financial aspect of the gallery other than to call the items bought to sale. Respondent denies selling raffle tickets, stating that vendors are allowed to offer their own raffle tickets for a drawing and prize, but respondent accepts no money or commission for this. Respondent denies that respondent does not give a closeout statement. Further, respondent denies calling auctions without a sponsor present. Respondent states that complaint is due to bitter feelings, and respondent denies doing anything illegally. Based on the information that was submitted, the recommendation is to dismiss.
So he said, she said.
There was really nothing to prove one way or the other, and a lot of the accusations I didn't see any way to absolutely prove. There appears to be a history, obviously, between these parties, and it's possible that more information could surface, in which case we can always reopen the complaint, but at this point it seemed to be a disagreement between the gentlemen.
Questions or discussion?
I move it.
Olson has moved. Is there a second? Mark, is that a second?
Howard did.
Howard did. Howard Phillips, second. All in favor? All against? Next item.
Numbers 2 and 3, 2013-005-161 and 2013-005-201. These complaints were opened due to findings from a previous complaint where an investigator determined that Respondent 2, an expired auction firm, and Respondent 1, an auctioneer, were holding auctions in Respondent 2's firm name despite the expired firm license. Respondent 1 admitted to calling bids for Respondent 2 since August 1, 2010, well after the firm license expired on February 28, 2007. Respondent 1 states that the owner of Respondent 2 asked Respondent 1 to work for Respondent 2 after attending one of that Respondent's auctions. Respondent 1 states that Respondent 1 agreed to start calling auctions and assumed Respondent 2 had a firm license. The firm had been in business for approximately 30 years. Respondent 1 states that Respondent 1 hung Respondent 1's license beside Respondent 2's firm license but failed to look at the date on the license and was unaware that Respondent 2's firm license was expired until the investigator for a previous complaint told Respondent 1 this fact. Respondent 1 states that Respondent 1 is not working for Respondent 2 anymore. The spouse of the owner for Respondent 2 expired firm submitted a response stating that they failed to mail the money in for the firm license, that the owner has health problems which prevented the owner from taking the 30-hour course to regain an active firm license for Respondent 2. The owner and spouse of Respondent 2 state that they were unaware that the firm license had expired, and once they were notified of this fact, all future sales were stopped and all advertisements for future sales were stopped, and there are no plans for future sales. The recommendation is to authorize formal hearings for both respondents with authorization to settle by consent order with a civil penalty of $250 for each respondent for a violation of Tennessee Code Annotated Section 62-19-10201.
Got complaints against 2 respondents.
Yes, the first one, sorry, it's hard that when it's anonymous. The first one is an individual. That person has an active auctioneer's license, is, I believe, the principal and owner of that individual's own firm, but during an investigation, as a response to a complaint that was filed against him that I don't believe had any other violations in it, except that the investigator went and discovered, based on the response, that this person claimed to be calling auctions for number 2, which at one time was a licensed auction firm but expired in 2007. And the auctioneer stated to the investigator, and this investigation was conducted this year, in 2013, for about 3 years, he had been calling auctions for an expired firm. Now, they appear to have stopped, but my recommendation was based on the length of the activity and the apparent lack of anyone's
6219-102A1, is that unlicensed activity?
It states that it's unlawful for any person to act or advertise or represent to be an auctioneer, apprentice auctioneer, or firm without holding a valid license issued by the Commission under this chapter or prior state law. It was based on the fact that they had said they had, shut down, and I searched the internet and they had. That was my basis, but of course you all have the discretion to change that. That's just the reason for the recommendation.
There was the auctioneer, was he the one, evidently this,
I believe it's a non-auctioneer owned firm. I'm almost positive. I can double check the file, but I believe the owner of the expired firm is not a licensee. It's expired, so some of that information comes off of our system once a firm once someone's in expired status. That information no longer shows up because it just shows up as expired. But this person claimed, we have an affidavit stating that that this auctioneer was calling all the auctions and handling things since 2010. Once it's expired, I don't know of a way to get
When
that.
they first get a license, we show the sponsor in the system, but when it the sponsor, I'm sorry, yes.
The way it reads, it doesn't sound like this auctioneer was the sponsor of the firm that they met, or they hooked up and they started doing stuff together after
After the license had already expired. So I imagine based on
read
the,
that.
yes, based on the dates, the license expired in 2007. This individual didn't become involved with the firm until 2010. So based on that fact, I imagine that never was the sponsoring auctioneer of record.
And had been in business for 30 years.
That's
See, that
We
gets-
don't,
Excuse me.
Go ahead, go ahead.
That gets right back down to what the rooms we're trying to do. See, it said that whoever's that sponsoring auctioneer was supposed to be the one handling those auctions for him. He couldn't go out and freelance.
Happened in East Tennessee.
I don't know, and I don't really want to, I don't know that I should give that information to ruin the anonymity of it.
what she's trying to keep you from figuring out.
That's exactly right.
That's the idea. That's why it's so hard to write these, to make them anonymous.
I mean,
So do we know if they were doing anything from '07 to '10, from the time he expired to the time this guy started doing
sound like
auctions for him?
they were doing auctions all that time.
The investigator did not did not provide me with that information. All that I found was the information from 2010 on.
But they stopped activity when?
They stated that once the investigator made them aware of it, that they stopped, and I found no
When was
evidence. I'll check the date of the investigator's report.
But you're not sure, I'm going to excuse myself from this.
Investigator visited the investigator visited in February of 2013, this year.
Well, they didn't stop activity until February of this year, right?
That is when the date of my report is, and it looks like the investigator met with them.
They
and-
operated for 6 years without a license?
Yes, and with the assistance of Respondent 1 for 3 of those years, by their own admission through affidavits.
I think the fine that was being recommended is mighty light in light of the fact that they operated for 6 years without a license, and there's no way they didn't know that. That's every auctioneer, you almost walk by that board every month to make sure you're not close someone.
Right, and like he said, he hung his license next to it and didn't notice the
Right,
date. But
right.
the range for a violation of this statute, 6219-102A1, and this could be for each of them, 'cause
Right,
like I said, this is
right.
2 separate matters, is $0 to $1,000.
Okay.
So,
Comments or questions?
It's what we've been doing.
don't have, the investigator didn't give us a number of sales that have been conducted. They told me the frequency with which they auctioned, but we don't have the exact number of that.
What legal's recommending here, from what I read this, is to settle it, either have a formal hearing, or if they pay the fine, to settle it, not have the formal hearing.
That's right.
That's
We
correct.
could just call them in for a formal hearing if we wanted to, and go from there, or
You
make it
can al-
$1,000 if they settle it, but I'm not sure that's even enough.
I believe that,
guess
they do
it's-
this in the real estate commission sometimes. For an unlicensed individual like this firm, obviously the only option, well, can you bypass a consent order, Mark? I actually don't know, and just authorize formal hearings. And so, and at that point, there would probably be more.
But the firm can't get their license back anyway unless they come retest.
Right, and they don't plan to do it, they stated in their response, so it would just be a matter of the civil penalty,
The
which,
most money we can get and be done with it.
Chair will entertain a motion.
I'll make a motion, we Well, I'm just talking about, in this case, we don't, for each one of
Right.
these, the auctioneer and the firm.
Is that a motion?
That's a motion.
Just your motion is that we fine them $1,000 each or a formal hearing, whichever they choose. Is there a second to that motion?
I'll second.
Seconded by Bobby. Any questions or comments, discussion?
How are we going to find out how relations there are?
I don't think there's any way. I just made this, I didn't mean to say per auction. I just mean
Or respond.
Or respondent?
change the penalty that Julie came up with, $1,000 to each one of them.
It came down to a hearing, of course, they would be in here and there'd be testimony, and I imagine that would be something they would testify to. When they spoke with the auctioneer, the investigator, the information given to that investigator, which is the best that I have, was that they had been conducting auctions weekly and biweekly, and that person had been the auctioneer since 2010.
Yeah.
So that's the best of my information. We can try to figure out that number based on that affidavit, or you can just proceed with your motion. But that's the best of the information that I have from the investigator.
The only person here that's going to have any skin in the game is respondent number one, the auctioneer, because he's still got a valid license and still wants to be in the business. The firm probably doesn't care at this point. Other discussion? Motion's been made and seconded. All in favor? All against? Motion passes.
Number 4, 2013-005481. The complainant alleges that respondent, an unlicensed company located out of state, is neither a licensed real estate firm nor a licensed auction firm and is conducting an auction of multiple properties located in Tennessee. Specifically, complainant alleges that respondent has sent out numerous sales packages to prospective purchasers soliciting sealed bids for the sale of several properties, that respondent is requiring earnest money to be submitted to respondent in another state where respondent is located. Complainant alleges that respondent is misrepresenting itself in respondent's advertising, which states that respondent's auction is being conducted in conjunction with an individual who is a licensed broker and auctioneer. Respondent submitted a response through an attorney stating that the complaint and allegations are not clear and appear to be a blanket-type complaint submitted to the Auctioneer Commission, the Real Estate Commission, and possibly more regulatory agencies. Respondent's attorney states that respondent is working with a properly licensed real estate broker who is also a properly licensed Tennessee auctioneer and has been taking sealed bids with regard to real property in Tennessee. Respondent quotes Tennessee Code annotated Section 6219-1012 that an auction is defined as a sales transaction conducted by means of oral or written exchange between an auctioneer and members of the audience, which exchange consists of a series of invitations for offers for the purchase of goods or real estate made by the auctioneer and offers to purchase made by members of the audience, culminating in the acceptance by the auctioneer of the highest or most favorable offer made by a member of the participating audience. Respondent's attorney states that here there is no written exchange, no audience, and no series of invitations for offers. Respondent's bid packet, a copy of which was submitted by complainant, indicates that respondent would be the recipient of all sealed bids and present said bids to the seller, with the seller then having the right to either accept or reject the bids. However, the materials also state that after receiving said sealed bids, the seller may elect to solicit a best and final offer from bidders, which can then be accepted by the seller. Respondent's attorney submitted additional information stating that as soon as complaints were filed against respondent obtained Tennessee counsel, and after discussing the matter with legal counsel, took a number of steps, including terminating respondent's sealed bid agreement with the property owner, and the property owner engaged a licensed auction firm, real estate firm, as broker for the sale, removing all advertisements for respondent conducting the sale from respondent's website, and reflecting the auction firm, real estate firm as the broker in advertisements. All bids were sent to the property owner with the bid deposit checks made to the owner's title company, and the bid deadline was pushed back slightly to ensure a smooth transition for the broker auctioneer and his firm who handled the sale. Respondent's attorney states that respondent expended significant effort and cost in ensuring that respondent did everything necessary to address the complaint allegations and ensure they were compliant with Tennessee law in the future, auctioneer. Respondent's attorney states that any wrongdoing was not intentional has been corrected. In light of this information, my recommendation was a letter of warning regarding Tennessee Code annotated Section 6219-1012, the definition of auction, and 6219-102 license requirements.
I think this is a case where you're asking forgiveness for after the fact. This person should have checked with the state of Tennessee to see what the auction rules were before he commenced to have an auction of real estate especially.
Well, they did advertise it, but they did not actually hold the sale, and that was the
They
reason.
were attempting to have the auction and would have had the auction had this complaint not been filed properly.
They were under the impression, I don't know if they received bad advice, that they thought it did not constitute an auction, and when they obtained counsel within this state after the complaints were filed, they were advised to change accordingly.
Advertising it as an auction.
They were advertising it as a sealed bid sale.
Do you have any of the advertising that they sent out?
I have a copy of the bid packet, which is a number of pages, and like I said, I tried to summarize some of the information contained in that regarding the fact that bids were to be submitted out of state to this respondent, and they were arguing there was no exchange. However, when I read into it, it appeared that best and final offer language did appear to constitute an exchange.
You used the word bid.
That's what I was-
I'm going to tell you, that tells me it's an auction. And quite honestly, the line's getting blurred more and more across the state when we have these companies that are, quote-unquote, have these auction divisions inside their real estate companies, and they don't have an auctioneer. I mean, they say we have an auction division. I mean, there's a nationally known real estate company that conducted a sale in Memphis. They did use somebody that was licensed in the state, but I mean, it's a real fuzzy line, and I think the commission here we have to be kind of black and white about this with people so that, it's clear when you fall within the rules and when you don't fall within the rules. That's my only comment.
That's what caught my attention was the word bid, and any time that the public hears bid, their ears are trained that, hey, auction, we'll get a good buy. And
Auction when you hear the word bid?
Unless it says sealed.
It did say sealed bid sale is what it was titled, I believe.
use the word auction.
I don't believe it did. It was a lengthy packet, and I have not checked.
It uses the word auction and the word bid. I would have a problem.
I just want to say, for the purposes of explaining my recommendation, that we had someone in the past, an out-of-state company, that came in. Once they were advised of the rules, they obtained counsel, they expended the effort that these people did to pull the sale, and they received a letter of warning. And this auction was conducted in compliance in the end, and these people have been well advised by legal counsel that this was, it was not a good idea to continue, and so that was the reason for it. I'm looking for this.
I have to applaud him for getting counsel and looking into the statute so that they can be consistent with the statute.
And according to their attorney, they expended a lot of money undoing what they had done, which doesn't necessarily excuse it, but is something that he asked me to advise you all of. He made that very clear. And I did speak with the attorney. I didn't speak to anybody with them themselves. Like I said, it is a long packet, but it does not call it. It repeatedly refers to it as a sealed bid sale. If it says auction, it may only be one or two times in the number of pages, and I don't see.
Did they advertise it in the newspaper, or did they just advertise it on the web?
I don't know that. The complainant didn't provide me with that information. I believe it looks like the type of packet, because of the number of pages, that may have been emailed out to a number of interested buyers. It looks too lengthy to be an advertisement, but the complainant did not specify how it was sent out. So it was on the website, because the attorney referenced that being pulled.
Other questions or discussion on this?
I have a question. I would like to know, is this packet, the way it was presented to begin with, is that legal in the state of Tennessee?
It's based on my review of looking at the way that it was outlined, with the sealed bids going to these people out of state. With the addition of the best and final offer, that does appear to at least arguably constitute a written exchange, which I believe, would possibly make this fall within the definition of an auction based on that back and forth. I think if it was just merely submitting the bids and somebody accepting it, you could say there wasn't a written exchange, but this best and final offer language was what gave me pause for concern falling under the definition.
I think it was an attempt to have an auction, the way it reads.
I'd like to make a motion as to this case. Gary Cunningham to accept council's recommendation. Is there a second?
I'll second.
Seconded by Marvin Alexander. Any discussion?
Well, I'm kind of like Howard. I think it was a case of whether they was going to beg forgiveness rather than ask permission, but
All in favor of the motion? All against?
Yes.
One against, 3-4, motion passes.
013005491. The complainant, an auctioneer broker, alleges that his client wanted to place an offer on a property but was told that the property was just listed under auction terms with Respondent, which is an out-of-state online auction company. Complainant alleges that he looked at the property on Respondent's website and a bid could not be placed at that time. Further, complainant states that the website stated that an auction date, which was in the middle of the following month, Complainant states that his client was interested in placing a bid, and when the client visited complainant's office approximately 1 week before the auction date, to determine whether an early bid could be made, complainant states that Respondent's website already showed the property is sold. Complainant contacted Respondent regarding the sale of the property prior to the listed auction date and states that complainant was told that if Respondent received an acceptable bid, that Respondent could sell it. Respondent submitted a response stating there was a system process issue with Respondent's website which caused confusion over how the auction dates of this property were displayed. Respondent states that they were unaware of their website issue until this complaint. Respondent states that there was no intent to cause confusion. The property was not sold prior to the intended auction date. Typically, Respondent states that Respondent's online-only auction begins when the property is loaded to Respondent's website and ends in approximately 28 days, which is the auction end date, which is specified on the screen. Respondent states that a property is sold when a bid is made through the online system, which the seller accepts. Respondent states that at the same screen there are bidding instructions and a Bid Now button and a countdown indicator that allows bidders to know how much time remains before the auction end date. As to the seller of the subject property, Respondent states that the Respondent was asked to modify the timing on the property for a 21-day marketing period, followed by a 7-day online auction where the Bid Now button would be displayed and the days left to bid shown. Respondent states that if the property had not sold, there would have been an additional 14-day post-sale period, which would also allow bidding. At the end of the 14-day post-sale period, Respondent states that the auction would end and be taken from the website if no acceptable bid was made and accepted by the seller. With regard to the subject property, Respondent states that the system incorrectly listed the auction date as a date certain instead of the intention that the date should have been listed as the end of the 14-day post-sale period. Additionally, Respondent states that the Bid Now button was not visible until after the 21-day marketing period, which would explain why the button and the wording regarding the time remaining to bid was not displayed on Respondent's website when complainant viewed it the first time. Respondent states that this additional had this additional wording already been included on the website, it would have assisted in clarifying as to when bids could be made and accepted. Respondent states that the Bid Now button for the subject property was first displayed on their website at the end of the 21-day marketing period, and another buyer submitted an online bid on the property on the following day. Respondent states that when the bid is received, respondent notifies the bidder that the bids will be considered in the order they are received and may be approved by the seller at any time. The seller states that the seller accepted the bid. Once the bid is accepted, respondent states that the sold banner on respondent's website is automatically displayed on the property that is sold, which is why when complainant viewed the website a second time with the intent of making an early bid, the property was listed as sold. Respondent admits that respondent's website system process issue caused online information for the subject property to be potentially confusing depending on when the site was viewed, but states that the error has been corrected to eliminate confusion in the future. Respondents say that there was no intent to mislead or to sell a property prior to the intended auction period, but it was simply a case of their computer system not displaying the information as intended for an auction involving a timeline that varied from a customary timeline. The recommendation on this one is to dismiss.
You know, if there was any, I don't know, what would the violation have been?
I would assume misleading advertising. That's what the complainant appeared to be alleging, that, it had an end date. I checked back and it was already sold, and this person states that, our general practice is to do it this way. When this was altered, our system didn't adequately convey that, and it wasn't checked at the correct times, and it was just a mistake on their part, which have been they've noted as a problem in the future. Like I spoke with an individual that was a representative of respondent and said, this is not our typical outline, so I can't say it's been corrected in the future because we'd have a typically different format, but we've noted this problem in the event of an alternate schedule for a seller in the future.
Make a motion to accept council's advice.
Howard Phillips has made a motion to accept council's recommendation for dismissal. Is there a second?
I'll second.
Marvin Alexander has seconded. Any discussion? All in favor? All against? Motion passes.
The next one is 2013-005731. An anonymous complainant submitted a complaint naming multiple individuals and entities for various violations. With regard to this respondent, a gallery, the complainant seems to allege that the respondent gallery is unlicensed and uses unlicensed auctioneers to call bids. The anonymous complainant also suggests that an individual, the owner of respondent gallery in the following complaint, and his brother are operating this respondent gallery. A response was submitted by the owner of this respondent gallery. The owner states that the anonymous complainant misidentified the owner of this respondent as brother of the other individual who the complainant addressed in the complaint, and they are merely friends who both own galleries. The owner states that respondent is a licensed gallery and enclosed a copy of said license, and states that a licensed auctioneer has been calling auctions for respondent for several years. A copy of that auctioneer's license was also provided. Respondent states that these licenses are displayed for anyone to see. Legal counsel contacted the licensed auctioneer named by respondent's owner, who confirmed the information provided by respondent's owner. There does not appear to be any evidence of a violation by respondent, and therefore the recommendation is to dismiss.
Where the anonymous complaint thought that they weren't licensed.
It was unclear. There's a number that we're going to do. It named a bunch of people, and in some cases it was unclear, but the allegations from reading it seemed to be that this gallery didn't have a license and didn't use, it said had no license of any sort. We looked it up. It was a licensed gallery, so therefore we were able to send it out for response, and like I said, received this information from the owner. We'll see in some subsequent complaints. The next one appears to be a complaint of a very similar nature. The following one after that turns out it was an unlicensed gallery with unlicensed individuals, but there were a number of individuals named in the complaint. Unfortunately, however, when it's an anonymous complainant, I can't get the clarification I sometimes need, and I have to do the best I can. But
Right. This came through our website?
it was actually written in anonymously,
Okay.
but I don't believe we had any information about it. It didn't have any information on the complaint itself, and Donna didn't glean any from the envelope it was submitted in, so.
Go with legal's recommendation.
Been moved and seconded to accept legal's recommendation to dismiss. All in favor? All against? Motion passes.
2013005761. The same anonymous complainant above included this respondent gallery within the complaint. The complainant seems to allege that this respondent gallery is unlicensed and uses unlicensed auctioneers to call bids. Complainant states that the owner of respondent and his brother are operating this respondent gallery in the previous respondent gallery. Response was submitted by the owner of respondent gallery. The owner states that respondent is a licensed gallery and respondent has always used a licensed auctioneer to call auctions for respondent until such time as the owner, formerly apprentice auctioneer, obtained an auctioneer's license, which occurred around the same time as the complaint was filed. Legal counsel contacted the licensed auctioneer named by respondent's owner, who confirmed that he called auctions for the respondent gallery until the owner obtained an auctioneer's license. Respondent's owner states that the allegations are false and appears to have been filed by a competitor, and respondent follows all rules and regulations. At the current time, respondent's owner is a licensed auctioneer, the owner of a licensed auction firm, and the owner of this respondent gallery. There does not appear to be any evidence of a violation by the respondent, and therefore the recommendation is to dismiss.
Marvin has made a motion to accept it, the recommendation to dismiss, and Howard Phillips has seconded it. Any discussion? All in favor, say aye. All against? Motion passes. Number 8.
The next two complaints are 2013-005771 and 2013-005801. Complaints were opened against these respondents. Respondent 1 is an unlicensed gallery. Respondent 2 is an unlicensed individual, based on information contained within the anonymous complaint referenced in the previous complaints. The anonymous complainant states that respondents do not have a license of any kind. In the anonymous complaint, the complainant referenced Respondent 2 by a first name as the auctioneer for Respondent 1. Based on the complaint, which did not include an address or any other identifying information for Respondent 2 other than a first name, legal counsel conducted an located an internet advertisement referencing auctions held by Respondent 1 and noting Respondent 2's full name as the auctioneer. Complaints were sent to respondents at the address listed on the advertisement. The complaints were returned with notations of no such number and unable to forward. Legal counsel called the telephone number referenced on the online advertisement and reached an individual identified as Respondent 2. Respondent 2 states that Respondent 2 has an auction house. Respondent 1, where consigned items are sold, which is held twice weekly. Respondent 2 admitted there was no gallery license for Respondent 1, but denied that Respondent 2 was acting as the auctioneer, stating that a licensed auctioneer calls the auctions. Respondent 2 claims that Respondent 2 did not place the online advertisement. The recommendation is to authorize formal hearings for both respondents with authorization to settle by consent order. For Respondent 1, a consent order with a civil penalty of $500 for violation of Tennessee Code Annotated Section 6219-125. For Respondent 2, a consent order with a civil penalty of $500 for violation of Tennessee Code Annotated Section 6219-102A1.
This is all off of that same anonymous complaint.
All four of those, and I
Awesome.
believe that was the last one of that grouping. But like I said, this one I actually was able to obtain some information that they weren't licensed, and I was able to get a good address during that phone call as well.
They're having a bi-weekly auction and don't have a gallery license or an auctioneer's license for the...
This person doesn't have one. The individual claimed that he was not the one conducting the auctions, which doesn't make it in compliance anyway, but according to the anonymous complainant referencing that individual by the first name, and based on the fact that I located that online advertisement noting this individual as the auctioneer, all indications would point to the fact that this person is calling the auctions for it. Like I said, I did the best I could with an anonymous complaint and not having a very good address, and luckily I was able to reach this person by telephone, so... And you may, in light of what you all determined on a previous one, you may all determine that you want to increase the penalty for this. Again, the maximum is $1,000 for the violation, so...
I make a motion that we raise the penalty to $1,000 each.
Motion's been made. Is there a second?
Is there one penalty or two?
It's a separate statute for each one because one's an unlicensed gallery, so it's cited under the gallery statute, and then for respondent to the individual, it would be 6219-102A1, which states that it's unlawful for someone to represent themselves as an auctioneer without a license. So it would be two separate consent orders. Yeah, it's one statute for each one, two separate consent orders, which would contain two separate civil penalties, but for different statutes.
Motion correct.
I understood it to mean that you wanted to increase the amount in the consent order to $1,000 for each respondent. That's what I understood.
Who seconded that?
Yeah, it hadn't been seconded.
Second.
Bobby Colson is seconded. Is there any discussion on this? All in favor? It passes. Next item.
In 2013006931, this is another anonymous complaint. We had several in this batch, but this is a separate one, just to be clear. Anonymous complaint received against respondent, an auctioneer, the owner of the respondent gallery named in an anonymous complaint 2013005761, which we considered just before the last one, which states that respondent is conducting auctions without a sponsor at different locations. At the time the complaint was written, respondent was still an apprentice. Respondent became licensed as an auctioneer shortly afterward. Respondent submitted a response denying the allegations of the anonymous complainant and stating that the anonymous complainant is a fellow auctioneer who has a history of filing anonymous complaints. Respondent states that respondent had a sponsor since day one of being an apprentice auctioneer until respondent became a licensed auctioneer. Respondent states that respondent always used a licensed auctioneer when respondent only owned the gallery. However, respondent states that respondent now has an auctioneer's license and a firm license as well, and respondent has always operated legally. There does not appear to be any evidence of a violation by respondent, and therefore the recommendation is to dismiss.
Additional questions on that?
Recommendation.
Bobby Colson moved we accept the recommendation of dismissal. Is there a second?
Second.
Second by Howard. All in favor?
I want to ask a question.
Dave Marvin wants to have a discussion.
Respondent states that the respondent had a sponsor since day one.
He basically was just saying, I've had a sponsor all along until I became an auctioneer, was the gist of what the person was
So
saying.
I gathered he also owned the auction house.
He owned the auction gallery, yes.
He had a gallery.
That's correct. And now this person is an auctioneer.
Is that the same person that was involved with the first auction?
That was another anonymous complaint against that person's gallery.
Is sponsoring auctioneer involved in all these?
He claims that he was, like I said, without more information from an unidentified complainant. They said that he had auctions at several locations without a sponsor. It would be almost
But I mean, is this sponsoring auctioneer? There's just so many complaints there. It looks to me like there's something in the woodpile.
Well, they actually alleged two somewhat different things. One said that they didn't use licensed people at all, and I contacted the person who was holding the auctions for them, and that licensed individual said, I did call auctions for this gallery until the owner became licensed, and this is the owner.
He wasn't the principal auctioneer. I mean, he wasn't the sponsoring auctioneer.
He was not the sponsor of this apprentice when he was an apprentice. He was separately licensed as an auctioneer.
I have a question. I think I misunderstood. I thought you said when you started reading this one that it was a separate complaint from all the others.
It's another anonymous complaint. I don't know if it's the same person. I don't know if it's a different person. It's
Separate complaint.
It's a separate anonymous complaint. As to whether it's two different people or the same person, I I don't know.
You don't know if it's tied to these other three before this?
I don't know if it's the same person, a friend of that person. That's the difficulty with the anonymous complaints, and a lot of times we don't have the detail. And like I said, if I could have sent an investigator to see, it's difficult when someone just says they've been doing it at numerous times. It's be very difficult to get that person to provide information to incriminate themselves without more information.
Same people involved in all of it, except we don't know who the...
If it's one complaining or 4 or 5.
Well, it was 2 complainants, and one anonymous complainant submitted a complaint against multiple different entities, and then a second complaint was just against the owner of one of the individuals. It was also anonymous, yes.
So it could have been the same person.
We don't know. I'm not saying it is or it isn't.
Well,
That's just,
Don't make
it's
any
hard to know.
That's the fallacy of our gallery license. A person can come out of, get his apprentice license, go get him a gallery license, and then lots of times
Well, like I said, the first one said that it was an unlicensed person, and I contacted the licensee, and that person said, no, I've been doing it, actually. So it's actually slightly different allegations of a similar nature, but like I said, it's difficult to determine when you can't call the complainant and ask for clarification.
I'll stick by my second.
Been moved and second, we accept the recommendation of dismissal. All in favor? All against? Motion passes. Number 11.
2013008261. Complainant alleges that respondent, an auctioneer, posted an ad on Craigslist advertising an auction without including respondent's firm name within the ad. Complainant attached a copy of the ad which includes respondent's name and license number as the auctioneer and includes the gallery license number where the sale is taking place. Respondent submitted a response stating that respondent and the gallery were unaware of the advertisement until respondent received a copy of the complaint. Respondent states that a customer was trying to be a good Samaritan and post the auction on Craigslist to assist in advertising, but was not aware of the rules and regulations governing auctioneers. Respondent states that respondent has run an honest and respectable operation for many years without a complaint and hopes that this issue, which was out of respondent's control, does not jeopardize that reputation. There is no evidence contradicting respondent's explanation regarding the ad, and therefore the recommendation is to dismiss.
He didn't post the ad, one of his customers did.
That's what he claims, and I don't have any, when we receive a response, that response is sent to the complainant. There was nothing sent back contradicting that, and of course from a Craigslist ad, I couldn't tell who had placed it. So there is a advertising rule that says advertising in any form that is designed to give notice of an upcoming auction must include the name and license number of the auction firm or gallery responsible for holding the sale. In this instance, it did have the gallery license number where it was being held. It just didn't have the gallery name or this respondent, the licensed auctioneer, his firm. However, according to the rule, it would appear that if it was being at this gallery, it would have just needed the gallery's name and license number on there. And the license number was included, but like I said, I don't have any indication that it wasn't a good Samaritan, as he stated. I'm not sure. It's difficult to tell with Craigslist.
Question? Motion?
Take council's advice and dismiss.
second.
Seconded. All in favor?
Aye.
Next item.
20130099691. An anonymous complainant submitted copies of newspaper advertisements which included the name of respondent, unlicensed. It appears that the anonymous complainant was attempting to point out that respondent is attempting to represent itself in the auction advertisements as an auction firm without holding a firm license. A response was submitted by the individual who placed the ad, who is a licensed auctioneer and whose name is included within respondent's name. The individual states that he has been the principal auctioneer for a licensed auction firm since 1997, that all appropriate licenses and names were included on the advertisements submitted by the anonymous complainant. The advertisements do contain the name of a licensed firm at which the individual is a principal auctioneer, and also includes the firm license number as well as the individual's individual auctioneer's license number. The individual states that referencing respondent, which includes the individual's name and has been used for many years, is listed for the purpose of showing that respondent is the responsible auctioneer for the auction and not with the intent to mislead anyone. There does not appear to be a violation, and the recommendation is to dismiss.
Do we accept legal's recommendation?
Second.
Moved and seconded, we accept the recommendation of dismissal. All in favor?
Aye.
All right, next item.
2013-009781. Complainant is respondent's former sponsoring auctioneer who listed a number of allegations against respondent, including performing auctions without respondent's consent, advertising without a license number, advertising on the MLS, utilizing non-conforming signs and ads, and removing a listing under false pretenses. Complainant included a photograph of a sign advertising an auction, which does not appear to include the firm's license number. Respondent submitted a response stating that respondent did not need complainant's consent to perform an auction because complainant was no longer respondent's sponsor. Respondent has a new sponsor. With regard to the yard sign, respondent states that there was an error with the sign company wherein the firm numbers were left off, but the problem was corrected on the following day, and respondent attached a picture indicating proof of this. Respondent states that respondent has a right to advertise on the MLS and all advertising is compliant. As to the allegation of removing the listing under false pretenses, respondent states that respondent received the auction while working under complainant, and due to the actions of complainant, respondent states that the property owner became upset and fired the two, and complainant placed the advertising and removed the listing. It appears that there are negative feelings between complainant and respondent surrounding the end of their former working relationship. The only issue appears to be regarding the sign, to which respondent promptly corrected inclusion of the firm license numbers and the designation of respondent as apprentice auctioneer. However, the sign does not include respondent's license number. However, respondent acknowledged the mistake and stated it will not happen again in the future. The recommendation is a letter of instruction regarding Rule 0160-01-.12, subsection 7, which states that any advertisement placed by an apprentice must identify the apprentice as such, include the apprentice's license number and the name and license number of his or her sponsor's firm, as well as Rule 0160-01-.20, subsection 1, which states that advertising designed to give notice of an upcoming auction must have the name and license number of the firm or gallery responsible for holding the sale.
I have any questions regarding this as far as clearing up what's going on?
I'm sorry if it was confusing. I can clarify if needed.
He just left the company and went to another company is what happened, right?
This person switched sponsors. I'm not sure if it was two different companies, but the complainant was the previous sponsor. This person left left complainant and moved on with a new sponsor.
His little hard feelings, and they've corrected or tried to correct whatever was wrong, so I agree with, I move we go with legal's recommendation.
Bobby has moved that we accept this recommendation. Is there a second?
Second.
Seconded by Howard. All in favor? At this time, I think we need to take about a 5-minute break, and then we'll come back and start on item number 14.
I'm sorry.
Okay, we are reconvening after our break, and we're on item number 14. Julie, if you...
And I forgot to make this announcement earlier, but I did want to let you all know because it's new news since the May meeting. Mr. Green was promoted to Chief Counsel of Litigation for the Regulatory Boards Division, so he's now the boss man. He's here supervising.
Well, I'm here offering living proof of the old axiom that if you're incompetent, you can be fired, but if you're really incompetent, you can be promoted. So,
Do we call you Matlock?
yeah.
I've heard the song, "He's in the money now."
Yeah, I don't know about that.
He just got back from the beach, too.
Yeah,
Money then.
Here you go.
I'm sorry, I just forgot to mention that when he came in earlier, so. 14 and 15, 2013-009711 and 2013-012-681. 2 complaints were submitted against the same respondent, unlicensed, so that means both of these are the same company. One was anonymous, the other was not. Respondent conducts estate sales, and both complainants attached copies of respondent's internet advertisements, which include tag sales, but also offer online auctions for a portion of the items, which seems to be the topic at issue here. Based on the information from respondents' internet advertisements, it appears that the auctions are timed and online only. However, the website states that, on occasion, due to last-minute bids, the bidding time may be extended by an additional minute. Respondents' president sent responses on behalf of respondents stating it is their position that the estate sales that respondent is running do not require licensure based on a conversation respondent had with 2 employees in the commission's office and the licensing exemption. Specifically, respondent's president quoted Tennessee Code Annotated Section 6219-103-9 exemptions, which states the provisions of this chapter do not apply to, and subsection 9 states any fixed price or time listings which allow bidding on an internet website but do not constitute a simulcast of a live auction. Respondent's president states that Respondent is an estate sale company which is operated in a tag sale format with the recent addition to Respondent's website that allows customers to bid online for certain items in an upcoming estate sale in a manner similar to eBay. Respondent's president states that all bidding is done online in a timed format and there is no live bidding, and high bidders are required to pay for and collect the items at the location where the rest of the contents are being sold in the tag sale. Respondent's president states that based on the language from Tennessee Code Annotated Section 6219-1039, their position is that Respondent is operating legally and does not require licensure from the Commission. It does appear that Respondent is operating a timed online-only auction without a simulcast. However, it appears that there is a possibility for the time to be extended in certain circumstances. Additional information was submitted by an attorney on behalf of Respondent. Respondent's attorney states that Respondent has asserted that its auction format complies with the exemption found at Tennessee Code Annotated Section 6219-1039. However, Respondent's attorney states that Respondent recently made modifications to its online auction format, with auctions now ending at a fixed time instead of extending for additional minutes when a bid is placed at the last minute. The recommendation for this is to discuss, because I believe we've touched on this subject in the past, and this subject is addressed in some proposed rules that we're getting ready to start the rulemaking process on, but I wanted to discuss you all's interpretation of this statute and see what your thoughts were on how to address this issue with this respondent.
The statute now says fixed price or timed.
Right.
That's how they're getting around having to have an auction.
But I think if it extends, it throws it into a whole different realm.
And that's what I wanted to discuss with you all.
Personally.
Because
That's just my opinion, but, and I'm done. I think it's part of what we were proposing.
that's what we're discussing, because, the statute just states what it states, and, it's up to you all to make that determination of, do you think, is this a timed auction if it can extend minute?
Well, if they run an ad or somebody, and I think you can find it, let them bid, and they don't have a fixed timed ending. So you can bid up before the tag sale, and then they go and it's actually sold at the tag sale. Doesn't that get in?
That doesn't appear to be the issue here. The issue is that they have certain items that are done at the online auction. It's just the extension of
But
time.
what I'm saying is, if they let them bid on all these items, and then they're advertising on an item online, do you have a copy of their ad, or,
I do.
Does it say that these items are closed online, or they just let them bid before the tag sale?
Because this is the first one of this.
Sounds like that they have 2 separate categories. One's online only and one's a tag sale, but they're not the same
I think
stuff.
they're running them together.
A portion of the items are segregated into an online auction, which begins 2 weeks prior. The tag sale itself only lasts 2 days. I believe the way that they have this work is the bidding of the online bidding ends at the end of the first day of the tag sale, And so what that means is if those people want to come in and view those items and bid at the last minute, they can, but those items, the advertisement states that a portion of the items are segregated into that online auction, which begins about 2 weeks prior, ends at the end of day one of the actual tag sale, and then those items are sold in that format, and the remainder of the items are
It
sold.
didn't say they're selling that. There's nothing that says they sell that there.
I'm sorry, I don't...
It didn't say that they have ended the bidding.
It
I
states,
think they're playing on words. Here's what they're doing. They're going to let you bid on these items for 2 weeks. They want the exposure of them. Then they're going to have this tag sale, and they're going to enter who's the high bid and let the other people continue bidding, and it may be somebody's bid online. I believe it's actually a time-fixed auction is what I'm saying. It doesn't say that those items are declared sold at the end of that.
it does say the bidding for the auction item ends, it says in this advertisement, since it doesn't give anything away, Friday night at 8 p.m. It does declare an ending time.
There's an ending, but it doesn't declare whether that's the selling time.
It just says the bidding, it says the bidding ends, they could still be coming and buying it at the tag sale afterwards.
My website is set up. Now, I mean, if I put a certain auction on there, go to my website and bid up till 24 hours before the auction, or 12 hours. And that just gives me time to take your bid to the auction. Then I actually sell it at the auction. The sealed bid, I mean, not
They
the
just give you
sealed,
an opening bid at the auction, basically.
the online is over, but it's not, the item is not declared sold till the act.
Might buy, they might not.
I mean, I guess, if you're saying if an item isn't sold through the online auction, does it go forward to the...
I'm saying, if they didn't declare it sold and remove it from the tag sale.
Is that item sold to the high bidder online at Friday night at 8 o'clock, period?
That's what this advertisement indicates, and that is what was speaking with the president. He indicated certain items are designated for online auction,
Not in the tag sale.
but not in the tag sale. They're
That's what we're trying to say, is you can't be in both sales.
This doesn't say that here. It indicates that. I think you'd have to go and ask them, said, now, at 8 o'clock Friday night, are all those online auctions declared sold then and removed from the tag sale?
And on top
You
of
understand the
that,
question, Julie? In other words, if we've got we got a dining room set over here, and I bid on it online, and I'm the high bidder at 8 o'clock on Friday, am I the owner then of that item?
This indicates that because it says that, let's see, by bidding, they're entering into a binding contract, and that they will be held financially responsible for their actions. I mean, the indication from this is that if you are the high bidder, you're responsible for coming there and bringing the money to purchase it and pick up your item. That's
Oh, there's no further bidding at the tag sale on that item once that online auction is over?
No, there's no bidding
that's
at
what-
the tag sale, according to the president. I discussed this with him because I wanted to get some clarification as to how it operated, and I also wanted clarification regarding how long does this get extended at the end of it. The online auction is the only part where there's auctioning taking place. Now, I assume if there are no bids on an item, maybe it goes in as just part of the tag
that's the case,
sale,
yeah.
but his statement was, the auction is solely limited to being online. Now, the issue to me appeared to be the extension of time of that auction. Does that make it a timed auction anymore when it can be extended 1 to possibly 3 minutes? And the attorney states that they've removed that, but at the time of these two complaints, that was not the case. It can be extended for more than 1 minute. So if it says it ends at Friday at 8, the way it was operating previously, apparently if bids came in at the last minute, it could go to 8:01, then 8:02, then 8:03, possibly longer. Now, they say they've changed that, but again, at the time of these complaints, that's how these people were operating the online auctions.
No action being requested from the board on this, just
I wanted to determine if, you all would be the ones to interpret this statute. Obviously, I know based on I think it was Commissioner Alexander that suggested a rule making it clear that if the time is extended, that is no longer a timed auction. But it's up to you all to make that determination that that's what you think that this exemption means as it stands right now. But we don't think it's timed any longer. If it extends by minutes and therefore this person doesn't fall under an exemption, then it's your decision what type of action.
We're not really talking about it any longer. We're talking about this deal here, aren't we? This is fixed it. This is another case of begging forgiveness instead of asking permission.
Exactly. And like I said, I spoke with this person and I told him, I said, look, the reason I'm asking is this is the issue that I see. I said, the commission may have other issues. I said, but I want to know about this extension. And apparently the person got with an attorney and changed it after we spoke. And I told him, I said, I can't advise you as to what the commission will determine if you change that part of it. But, it's up to you all for interpretation.
They advertise as an auction, too. You say auction in the ads.
It's called, I'm not going to say the word, blank bidding and tag sale is what it is.
No, bidding. Bidding infers auction.
I think it's unlicensed activity myself, but I don't know how everybody else feels about it.
Who you licensed was people calling in to the auction and making bids right then on the spot.
That's one example.
That's one example, but this other one is still to be decided.
Our definition.
This might be where we need to decide.
The definition of that 61 says whether it's oral or not. Read that.
I think the question here is this a timed?
Getting back to what Miss Donna said, read us the definition of an auctioneer.
Of an auction? Auction means a sales transaction conducted by means of oral or written exchange between an auctioneer and members of the audience, which exchange consists of a series of invitation for offers for purchase of goods or real estate made by the auctioneer and offers to purchase made by members of the audience, culminating in the acceptance by the auctioneer of the highest or most favorable offer made by a member of the participating audience. That's under 6219-101, subsection 2.
Electronic bidding is the same as being in writing, is it not?
I think that you could definitely argue that. Because you're submitting a bid through an internet website, and there's several facets to this exemption. It's a fixed price or time listing that allows bidding on a website, but doesn't have a simulcast. So taking away the part about the simulcast, the question here is this a timed listing? Does it even meet the first part of that exemption?
If it extends forever while there's bidding, that is not timed, in my opinion.
I agree.
And I believe we've discussed this in the past with penny auctions, where people will bid and it'll extend, and I believe that I had read somewhere in a previous maybe news journal that wasn't considered a timed auction, and that's why I thought this would be worthy of discussion, because this extension of time that's going on here. And so if you all, as I'm understanding it, don't think it falls under the exemption, then that would make this unlicensed activity. So the question would be, what type of action do you all think is appropriate based on the facts that we have here?
And them other people $1,000. Or we could have
I disagree that it's I'm like you, I don't believe it's a timed auction. It's time, like it says, it ends at 8 o'clock on that Friday night, and they're going to sell that item there or not turn it down.
And they've claimed that that's the format that their attorney states they've switched to that.
They're taking bids.
they switched to it. Not on this case.
Well, it was after the complaints were filed that was changed. Like I said, it was changed afterward.
I make a motion, we send him a letter, since this hadn't been done. It is not a timed auction, and it would be looked at different in
And that might be something that we might consider putting in the chairman's note in the newsletter, you know, to pass this along to other licensees, because, you know, that's something that we do probably want to get the word out on, and like I said,
I'd rather wait and get that rule passed.
okay.
Won't find it for unlicensed activity.
Motion's been made by Marvin Alexander. Is there a second? There's no second. Is there another motion?
What was your motion?
Made a motion that we send them a letter of warning or and tell them that it's opinion of the commission, like we've discussed here, that if they're going to extend an auction, the bidding. We're not trying to change anything. It says if it's a timed auction,
It's been now seconded by Gary
I'll second it.
Cunningham. Is there any more discussion? All in favor, say aye. That's 2 votes.
Chairman's got a vote. Don't have.
I want to do a roll call vote.
Well, I mean, who's against it?
Yeah.
We got 2 for and 2 against.
He's not voting.
He's not voting.
I'm going to abstain.
You're going to abstain? I'll vote for it. There'll be 3 votes.
We had 2 anyway, so.
Okay, so then letter of warning explaining that the commission's interpretation of this exemption is that when
Right.
it extends past a designated time, you no longer fall under the exemption.
Exactly.
Got it. The following cases are being represented to the commission. They previously have been authorized for a formal hearing. However, attempts at service upon the respondents have warranted no result, and accordingly, it is the recommendation of the chief legal counsel for litigation to flag and close these matters. If these respondents are located, or should they contact the commission to attempt to obtain licensure, these matters can be reopened and proceeded upon. Numbers 1, 2, and 3, 2011-003511, 2011-002681, and 2011-003531. These complaints were brought before the Commission in 2011 alleging unlicensed activity as well as fraud in failing to pay the seller of items bought by unlicensed respondents. The complainant was able to get a judgment against the respondents in one case, and there were criminal charges filed, or a criminal complaint was filed against the respondents. The addresses that the department investigators found when sent to attempt to locate the respondents are now vacant or have someone else living there. The department has been unable to locate them since. The recommendation is to flag and close.
Discussion on this? Is there a motion?
Make a motion.
Howard Phillips has made the motion. There's a second.
I'll second.
Marvin Alexander seconded. Any more discussion? All in favor say aye. Aye. Motion passes.
4 and 5, 2010-020-651, 2010-020-652. This matter was opened in 2010 regarding a complaint and issue with this auction firm that declared bankruptcy in 2009 and a voluntary surrender of the firm license by consent order. Accordingly, this matter should not have been opened as it was part of the complaint. Further, the respondent firm declared bankruptcy and the commission could not collect a civil penalty. However, all parties, including this complainant, have received notice of the bankruptcy and the bankruptcy trustee in order to attempt to obtain relief, and therefore the recommendation is to flag and close.
Discussion? Motions?
I'll make a motion.
Motion made by Marvin, seconded by Howard. All in favor say aye.
Aye.
Next.
It's 2011-008881. This matter was brought before the Commission in 2011 regarding an unlicensed activity. The allegation involved an unlicensed person conducting an auction gallery at a flea market. The initial respondent was the owner of the flea market who rented out space to people. It was one of the people who rented space from the owner that was conducting the auction unbeknownst to him. The name of the unlicensed person was obtained, however, he has not been able to be located. The owner of the flea market appears to have had no knowledge of the auction. Legal has confirmed that the auction only occurred once and far as is known has not occurred again. Locating the person who conducted the auction has yielded no results, and therefore the recommendation is to flag and close.
Howard has made the motion, second. Alderman seconded. All in favor say aye. Aye. Motion passes. All right, so that's the end of your legal report, and you're going to do an update on proposed rules.
Right. At the last meeting in May, I had said that I would have these ready to do our regulatory flexibility analysis and move forward with the official rulemaking process at this meeting. However, there have been some changes in legislation where all of the commissions are now asked to add a rule specifically dealing with military applicants, and I want to get that in with this set of rules. So I ask, I'm sorry, I don't have them ready at this meeting, but I do plan to have them at the next meeting. I just want to get that included in the same group, and then at that point what we'll do is we'll take a look at all of these rules again. We'll do what is required by statute known as the regulatory flexibility analysis, which just considers a variety of things about those, and then that gets the ball rolling of getting the notice of rulemaking filed up with the Secretary of State, and then we would have that hearing a few months down the road.
That'll be in our October meeting, since we're probably not going to have it. We don't have a September meeting.
Right,
scheduled.
and that'll be ready to be done then, and then I suspect generally we have to schedule the official hearing a couple months out from that because it has to go up for a variety of signatures with the General Counsel, the Assistant Commissioner for our division, and it has to be sent up to the Governor's office before we can file the notice. So it will be a couple months after that before we can have the hearing, but I plan to get the ball officially rolling at the next
We have
meeting.
the rule with military applicants yet? Do we know what that's going to be or anything?
It's a statute, and we have to draft a
I heard
rule.
something about all that.
We have to draft a rule based on it,
Places
and I
were doing
just
that.
I just haven't gotten the
That'd be
wording
good.
ironed out. So I wanted to get that included with these rules rather than have another rulemaking process immediately following it. Since we hadn't officially started yet, I thought there was still time to include that rule in with it. So I just wanted to update you all on that,
Right.
and that's all I have. And I can turn it over to Donna unless you have anything else for me.
Hey, Donna, you want to take us through your report?
Here we go. If you will turn to tab 2, that's your monthly or board meeting complaint report comparison this year to last year on where we stand with pending complaints and complaints that are over the 180-day benchmark. 2012, there were 76 total complaints pending, 77% of which were over the 180 days. 2013, as of August 1st, there were 68 pending complaints, 64.71% over the 180 days, and I believe
What's the exact total associated with that case? Do you know?
39 or 40 is the last count I had. 39?
39, so
39 of
you
that.
take 39 off of 68 is where we are.
And some of them have clock stopping
29.
action. They're in
So we
line.
have 29 complaints at this time?
Other than those,
Yeah.
we don't have any that I have at this point that have had no clock stopping action on them. They're just in line for litigation other than those. So
How many this morning on the report? Did you-
there's 6 that were represented that would come out of that, and then pending complaints. These would not be ones over 180 days, but 15 of those, none of which were over the
Okay.
benchmarks.
So y'all feel like we're attending to these complaints in a timely manner at this point in time?
Better than it's ever been done before.
All right, that's good news.
Well, who gets excited because you don't get a complaint resolved in a timely manner? My opinion is that you're better to take your time and do it right and leave it on the books longer than to rush it and dismiss.
We don't ever, I mean, we have quarterly meetings with our assistant commissioner and then the chief legal counsels, and then once we have a deputy counsel again to replace Mr. Pugh, we have meetings about every quarter about that. And if there's a reason why one has been hung out there, say I've got an investigation out and I'm saying, look, it's over, they understand that. I just explain that we needed more information, the investigator has it, that takes a period of time, and when that's necessary, it's explained to them, and there have been no problems with that. Does it get presented? We have separate meetings than real estate.
They have so many.
They have a lot of complaints. They do. It's tough to keep them under.
There's a whole lot more realtors than there are.
There are a lot more. So
their numbers are going to be higher regardless. Okay.
No other questions about that? We'll turn to tab 3, and this is a report on your budget. As you know, the fiscal year ended June 30th. And I have the numbers that I've got here in this report given to me last week, and I was told this is the first run of the fiscal year-end report. So there will be more information added to these revenue and expenditure reports before we get to and it may be September or October before we get the very final numbers for fiscal year end.
It gives us a good sketch of where we are.
There's bills still coming in to be paid for that fiscal year. The right-hand column, as you'll see, is year-to-date 6/30/13. This is where your fees come from, and there are 3 other years there showing what fees were received in which areas for fiscal years 9 and 10, 10 and 11. But as of 6/30/13, there was a total of 100 auctioneers, apprentices, and public auto auctioneers. Licenses, reciprocals, renewals, reapplies, upgrades, transfers, retire, miscellaneous.
Been fairly consistent, hasn't it?
Bottom grid there is for the same fee structure for firms, galleries, and public auto auctions. And the grand total at the bottom, $251,547. That's the amount that the staff in my office brought out of the RBS system, the computer system where the fees are entered. The actual bottom number there, it says actual revenue as reported. That figure was given to me from administration, where they also see fees that come in from online renewals and through the Department of Revenue for renewals. So typically they're always just a little bit higher than what we pull out of the, but it'll all end up at the end in one lump sum when fiscal year ends. We'll have all that. The second page is your breakdown of expenditures. Same format, right-hand column is year-to-date through 6/30/13, showing your expenditures, $113,014. Out on down the line for travel, printing, communications, supplies, related services, state professional services, for total there of $37,144. Grand total $150,158 so far. Expenditures with your net revenue as I just reported.
Done a lot better job on the expense side, given the revenue that you have.
And the next page over is your Education and Recovery Fund report. Top block is your revenue, showing $69,450 received in initial application fees, reapply, and bottom shows the expenditure coming out of that report. $50,267 will be taken dollars, which will be added at the end of the year just to the prior fiscal year balance of 165.
It's our statutory requirement for our 150. What trends are you noticing, Don, in terms of number of applicants, number of licensees? Are y'all spotting any trends up or down? Is it just staying flat, or?
Staying pretty consistent. You can see from the fees that we get in that we had a drop last year, 11 and 12, in initial applicants and initial, but I think it's coming back up. Gave up their license and renewed.
Seeing younger people getting licensed, or they're not, or, that's what you've got to worry about is all of us old guys die out or retire or get out of the business or what have you, those numbers can be pretty large in the years to come, and you don't know whether or not you've got enough young people or middle-aged people to fill those gaps.
These actually teaches the classes. I don't even see the pictures on the applications to know the age or.
So what are you seeing?
I see it's down.
Down?
This year, it's been down. And we get these waves and then it stops again. So it's kind of coming.
Down about 20%.
What about his question on age? Are you getting younger people into it?
Right. Are the auction schools, are their enrollments staying fairly consistent, or are they all down, you saying, around 20%? Okay. What size is your normal class? 12? Yeah, that's a pretty good size drop.
You fit in an 18 to 25 group.
Jeff was talking about them old timers. I told him to speak for himself while I was.
Thank you.
Is that right, Mark?
Well, you hate to see an industry. My big concern is, as a fan of the live auction, is I see the online auctions starting to eke into taking over this industry, and I'd hate to see that.
I think back when I went to auction school, there was like 35 or 40 in there.
All right, Donna, you want to talk about the 2014 calendar?
Susan put together a tentative meeting schedule for you. We do need you to adopt the schedule so she can definitely reserve the room.
The only change that I might suggest is the conference and show next year runs from July the 8th through the 12th.
Really?
And so that would be the day after that Monday, July the 7th. And we've been kind of skipping the July meeting anyway, so I might want to suggest we not schedule that meeting.
And you can do that by statute. Y'all just have to have one per quarter, and if you have one in August,
Yeah, we'll have one in August like we
we
did.
would still meet that requirement.
Okay, good
So
deal.
just to put that out there for purposes of the statute.
And so with that one change, that's I would like to hear a motion that we adopt the calendar as they've laid it out here.
Is the January 6th, is that the second Monday?
First Monday. All of these are the first Mondays in that month.
Well, just because it's on there don't mean.
Schedule and decide at the point in time.
I move that we approve the 2014 meeting schedule. Not the 2014.
With July being out, or? Yeah.
Yes, with July being out.
Okay. It's been moved. Is there a second?
Second.
Seconded by Howard. All in favor? And it passes. So you have your scheduled meeting schedule for 2014. Reciprocal agreements, we're going to have a discussion about that.
At our last meeting, I reported that I had received all but 7 or 8 agreements from with, which are a total of 18. I had written all 18 states and told them that we think our agreements were lost in the flood when that other building flooded 3 years ago. And I asked all the states if they would provide me with whatever copy they might have between their state and Tennessee. I got responses back from all but 8 of those, and since our last meeting, I have contacted personally all 8 states and received everything that they had to give me, which left me with 5 that told me personally that there was no agreement. Let's say Georgia, for example, said that they don't have a written agreement with any state. What they will do is accept and provide a reciprocal agreement to any applicant who can show their life. Indiana, they say that they don't have copies, but they may draft one, a new one, to send to us for signing. Haven't got that yet. Kentucky, they don't have a copy, didn't respond to the letter. I did talk to them personally. Ohio, they want you to sign. They've sent in a new agreement that they want you to sign. Books under the Ohio tab. So if one of you would take that out of your over it and decide whether you want to honor that agreement.
The old
Ohio.
ones. The old ones.
One thing we need to be sure on these agreements that applicate with that state and not be a resident. Tennessee, you have to be a resident of that state. And we want to be sure that whenever they sit in Arkansas, you can't reciprocate through Ohio.
We won't reciprocate with a post office box.
Director from Georgia that question, did they have to reside in the state?
I'd like Tennessee to change, but
Florida's not that way, I can tell you. Florida, you got to reside in the state that you're reciprocating from. Or mutual recognition is what they call it.
A lot of states are getting away from that, apparently. One other state, Texas, they're the same thing. If the applicant can prove that their home state laws are equal to or greater than laws there of Texas, then they will issue the license.
The only one that we need to worry about is Ohio at this point.
I was asking you to enter into the new reciprocal agreement they provided there.
Doesn't appear to specifically state the concern about the non-resident issue. I can get with, I think their attorney was the one that actually sent this over. I can get with him and express that that's a concern of you all. We can have that spelled out.
I think we'd like to add that.
There's no requirement that you sign this. I can say that, we have this in our statute. What's the deal in Ohio? We're not really interested in signing this unless it sets that out. So, I can work with him on that and get back with y'all at the next meeting on that.
Nothing in this agreement that says they have to be in Ohio for Tennessee to recognize them for being
Right.
mutually.
Yeah, that they have to be licensed in that state and
Have to be a resident of
domiciled.
Ohio in order to recognize the fact that they're using their Ohio license to get reciprocity in Tennessee.
Yeah, it just says auctioneers licensed by the state of Ohio.
Right.
You
Yeah,
could
you
maybe
could live
just
in
add in
California.
domiciled in the state of
Right,
Ohio,
exactly.
but
Yeah.
that's something I can discuss with him and see if we can get a revised
Do you
agreement.
mind?
I don't mind
We'll
at all.
table that until you have a chance to.
Sure.
Y'all in agreement with that? Everybody? Okay.
Questions on reciprocity and those agreements? I have a question that ties in with that. With the reciprocity, and specifically the letters of good standing from the other states that following your convention in July, there was some discussion at your meeting about whether states will accept those letters of good standing via email.
I was going to just give you a quick report on the NALOA meeting that Marvin and I attended. It was one of the better attended NALOA meetings that we had. We had it set up where people could dial in by conference call, and we had probably, 5 or 6 states that we had dialed in, from Texas to North Carolina, you name it, were there in attendance by conference call. It was a little bit cumbersome, but it also encouraged participation. We did extend the contract for the executive director for 3 years, so that's not going to be an annually renewable contract, so she's good for 3 years now. And we're really we had a good discussion about how to increase membership, and they were going to work on some ideas on how to get what the benefits of being a member of NALOA are out to all the different states. With that being said, we did have a lengthy discussion about emails and letters of good standing by email. Everybody seems to be going to it. I think we ought to adopt that as well. Especially, but it has to be an email directly from that agency to you, not this. Yeah, they said I'm in good standing, and here's my email saying they said that. It has to be a direct email from that agency saying that they're in good standing, and it just saves a lot of time and effort on the part of these agencies where you're getting a lot of these requests and you're having to draft letters and da-da-da-da. So I'm sure you're seeing some of that where you're being asked for letters of good standing for auctioneers.
And she was doing a survey. Directive from the commission before I responded, so
Sure.
if you all allow that.
Anybody wanted to talk about that? Have a discussion about it? Seems like it's inevitable that that's what's going to happen.
Well, emails are something that if you think that you can do it and not make mistakes on it.
Well, they can. The good thing about email now is you can identify its sender as to who actually sent it by the URL. And
TN.gov.
yeah,
have good people in charge, so I do not have a problem.
Harry's business would be tough without email.
Sure would. Sure would.
All right, so that would be, I think, the wish of this board, that we pursue that and be an early adopter, as they say.
Got that on record, we can go in the minutes, and Susan sent all of you something recently by email asking you Susan
I need the
says,
text one and the email.
says you're the only one that has not, Mr. Alexander.
Excuse me.
I like how they asked and then called you out.
Let's go back to that, what we were talking about, begging for forgiveness instead of asking permission.
There you go.
We need you all. Well,
That was an anonymous comment, wasn't it, Mark?
the
2
statement,
seconds.
what I heard from administration was, make your boards sign up. So, Marvin,
You've been so admonished.
It's going to be a good system
Is that the
because
end
like
of
when we
your
do our
report, Don?
rulemaking, anybody that signed up for that, they'll get an email notification, and it's just a good way.
You don't
of
necessarily have to
keeping-
be a board member to sign up for that.
Oh, no,
So
any
anybody can
licensed
sign up.
city,
Oh, that'd
yeah.
be good to tell people about.
Right.
Would be good for the newsletter. There you go, there's your first article. Dang, why y'all didn't come up with that one? I would.
6 months ago, they started sending
Two good
out,
ideas.
unbeknownst to the directors, notices on renewal statements that, hey, sign up for notify. So, I think.
We can tell people about that and tell them to do it, and encourage them to do it.
Yeah, we only have like a third of the licensees so far signed up, or less than a third.
Well, we can encourage that in the newsletter. And about timed auctions. Those are our 2 articles. Is that in your report, Donna? Is there any unfinished or new business to be brought before this board?
Yes. Can I have 30 seconds?
Howard, you have the floor.
On complaints, I don't know, and I'm sure that all commissioners have phone calls from people in the community of an auction that's being conducted without a license or some kind of activity going on. And my question is, if a commissioner sends advertisement in and stuff to back up the complaint that they have received, is that really the board member filing a complaint?
If we were, it would probably be more Donna answering that question because she opens them. But if we receive something from a commissioner, many times our files are open records. For us to conceal that, it came from an individual would be difficult if we have an open records request. Probably the best course of action if you have an individual contact you with a potential violation, which I think this has happened maybe to Commissioner Morris in the past, and he's just told the person, hey, you need to get in contact with Donna, instead of taking it from them and bringing it in. Maybe just, remove yourself from that process, try to cut them off at the beginning and go, hey, here's what you need to do to file the complaint yourself, is probably the best way to avoid it.
My question is, if I send you advertising, an ad that's run in the newspaper, on TV, or wherever it's run, and I mail it to you, how am I filing a complaint? I'm simply opening up the eyes of the commission that in Weaverville, North Carolina, there's a guy conducting an auction without a license. And
Everybody has a right to know who their accuser is. I mean, if you're going to send me something with your name on
we
it.
had today, we had anonymous.
Well, if you send it to me anonymous, I don't know who it is.
In these cases, these are people that have stuffed something in an envelope, put no return address, not signed anything, so we have to open them as an anonymous. I guess, I thought you were saying if you come in and hand it to Donna, or if you email it to Donna, or you mail it to Donna with your return address label on it, once Donna knows who the person is, or we've had people that try to claim that they're anonymous on internet submitted complaints, but then they'll put their name at the bottom. Once it's on there, the name's on there, we can't remove
Their
that.
fax number and name is at the top.
Yeah, and so there's a difference. When we say that these are anonymous, these are truly ones we've gotten with no indication of who or where it came from, other than
And it
where.
was done on purpose, though.
We haven't redacted any information.
No, we don't do that, just because if, it's an open record, our files are, and from now, infrequently, we will have media requests for open records requests, and if it were shown that we were taking off board members' names, especially if that board member had voted and participated in it, that could cause some problems. So probably the best course of action is to, if somebody gives you information, have them directly contact
I do,
us.
Howard. If I get a complaint, I say, look, don't make it to me. Call.
Yeah, I think you
call
actually cut them off. You're like, look, I cut them off and just
I
said.
do. I didn't want to hear it.
Well, I don't want to hear it either, but by the same token, I don't like to see people out here operating an auction without a license, and people, the public, are afraid of the Tennessee Auctioneer Commission like it's some communistic outfit, and most of them will not send a complaint in. And if I need to continue to do so and sign my name to it, I will. But we need to, looks to me like you should be protected in some way. If I send one in and I don't sign it or anything, then it's anonymous. Is that true?
We wouldn't know where it came from. But you can also likewise, you're a member, you're free to submit complaints and put your name on. All that would mean would be you would just recuse yourself from voting, or if it came to a hearing, you would recuse yourself. But, you're free to do that as well, because you have just as much right to file a complaint as any other member of the public or other practitioner. It's just it would come down to a point where you'd have knowledge, and when I presented it, you would recuse, or if it came to a formal hearing, you would recuse, and that's kind of how that would go. And you have every right to do that.
One thing that folks that open the mail and all that fun stuff, we get a lot of anonymous complaints, so to speak, without specific information. We might get just an advertisement and firm number missing or something. They won't put a note on there. They just send us an advertisement and write, is this legal?
What's going on?
Circle. Yeah. And first of all, you don't know where the advertisement came from because it's clipped out
How
or
old
it's
it
ripped
is,
out,
or-
so we don't know what publication it was in, what the date was. So there's very little. Out and Julie's running around, what is this? What do you think the violation is? I think if somebody's going to send in a complaint, they need to tell us what that complaint is. Don't send something for us just to kind of
I agree with that.
figure out.
Okay. That was my question.
So-
That was my answer.
Does that mean you're going to be using email? I'm not sure.
So what?
You don't know if that meant you was gonna be using email, he wasn't clear on me.
He's going to scan it and send it in. Any other new business or old business?
I move with John.
Then move to adjourn, a second?
Yeah.
Seconded by Marvin. All in favor, stand up and leave.
Good job, Mr. Chairman.
Don't you know I have policed our area over here?
Well, I was going to introduce y'all to the